That is the people of the state of Michigan versus Christopher Hill. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Christopher Hill.
And sir, you are Christopher Hill, is that correct?
Sir.
All right, thank you. This is the time set for final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter is not present today. None of our subpoenas for today went out last week. However, the people have been unable to get in touch with the victim on this matter since the case was initiated. I expect a motion for the defense.
Mr. Lee.
Thank you, Your Honor. Given the lack of cooperation from the complaining witness, the defense would request a dismissal of this case.
Right, so the people, based on the defense motion, the people will, and the people's statements, the court will issue a dismissal without prejudice in the matter, which is being printed. That means that the case can be reissued if they choose to, but for our purposes today, the case is dismissed. All right, sir? I'll sign that. Let's print it out. I'm in possession of the order of acquittal or nollie pros on 24-03-256. Based on the defense motion, I will sign without prejudice as previously indicated. Anything else for the record in docket 24-03-256, Ms. Wilson?
Just that the no contact order takes about 24 hours at least to purge from the system.
Any pretrial orders would take about a day to purge from the computer system, just so you're aware of that. Anything else, Mr. Lee?
Nothing further. Thank you.
All right, you're all set. Thank you for your appearance today.
Thank you.
What's that? Mm-hmm. Hmm? Oh, really? Hmm.
All right, so we're on the record in docket 24-03-129. That is the city of people of the state of Michigan versus Timothy Schmidt. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Schmidt.
And sir, you are Timothy Schmidt, is that correct?
I am.
Thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think we're going to be requesting a jury trial date.
That's correct, Your Honor.
So the jury trial date, it will be at this time.
January 14th at 8 o'clock.
It's set for January 14th at 8 o'clock. Instructions to be due the week before. Anything else for the record in 24-03-129, Ms. Wilson?
Not for the people.
Mr. Raleigh.
No, Your Honor.
All right, I'll see everybody here on January 14th at 8 o'clock. Thank you, Mr. Schmidt, for your appearance. So Bryant is on Zoom.
Yes, on Mr. Dakin.
Dakenbring.
If she's ready, we're ready.
Ms. O'Brien, are you ready on Mr. Dakenbring?
We are, Your Honor. Thank you.
I believe he's sitting next to Ms.
Okay,
Bryant.
perfect. All right, so we're on the record in docket 24-03-376. That is people of the state of Michigan versus Gerald Dakenbring. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. O'Brien.
Attorney Ino Bryant on behalf of the defendant Gerald Dankenbring, who is present and seated to my left, Your Honor.
Gerald Dank.
And sir, you are Gerald Dakenbring, is that correct?
Correct.
And you can hear me all right, Mr. Dakenbring?
I can.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe all the discovery that was requested has been updated and shared. If that's the case, then I think we're going to be requesting a final trial.
Okay. Is that a fair statement, Ms. O'Brien?
It is, Your Honor. Thank you.
So we'll set for final pretrial,
January 7th and 8th.
January 7th at 8:30. So we've set for final pretrial on January 7th at 8:30. Anything else for the record in 24-03-376, Ms. Wilson?
Not for the people.
Ms. O'Brien,
Nothing for us, Your Honor. Thank you.
you should be all set. Thank you for your appearance today.
Thank you, Your Honor. Merry Christmas.
Merry Christmas.
Thank you.
If he's,
Is there a grant need on Zoom?
that's,
No? Okay, we can give a minute. Yeah, you are. Just hoping to get you out if you were.
Yeah.
We can wait a minute though.
the only, I see Mr. Marin. So, Mr. Marin, I'm going to put you in room 1 with your public defender, Mr. Raleigh, okay? Mr. Marin?
Yep, I'm here.
Okay, I'm gonna put you in room 1 with your public defender.
Okay.
So you should get a prompt to go to room 1.
Yeah, that's true.
Mr. Raleigh, we had Mr. Marin in a breakout room. And then we just lost him.
Oh.
So I'm gonna put you in room 1 and then I'll wait for him to come back and then hopefully you'll be all right. I'll just put him in room 1.
Okay, thank you.
There he is. There we go.
This is Jake. He's one of our temp APAs. He's getting ready to take the bar again. And then this is Gabby. She is one of our new APAs.
All right, Mr. Mead, we'll call your case. We're on the record in docket 24-03524. That is People of the State of Michigan versus Grant Mead. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And from the Abood Law Firm, correct?
Yes, Your Honor. Michael Anderson on behalf of Mr. Mead, who does appear via Zoom.
All right. And sir, you are Grant Mead, is that correct?
Yes, sir, I am.
And you can hear me all right, Mr. Mead?
Yes, Your Honor, I can.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. In reviewing the file and in consultation with the victim, the people have determined that it is not in the interest of justice to proceed on this file. I do have a nollie prepared whenever the court's ready.
Okay.
Well, I don't have it prepared. Ms. Holden had it and I signed it.
So I have the nollie someplace.
I have it whenever you're ready.
All right. All right, based on the representations of counsel in the interest of justice, I'm gonna sign the nollie pros for 24-03524. This case is dismissed without prejudice, which means that people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. All right, Mr. Mead?
Yes, Your Honor, I understand. Thank you.
All right. Anything else for the record in docket 24-03524, Ms. Wilson?
Just that it takes about 24 hours for the no contact to be lifted from lien.
Yeah, I'd give about a day to purge just to make sure that the pretrial conditions are all set. Mr. Anderson?
Nothing further. Thank you.
All right. You're all set, Mr. Mead. Thank you for your appearance today.
Thank you, Your Honor.
We'll see you, Mr. Anderson.
Thank you, sir.
I think so, yeah. She told me she might be here.
Okay.
Yeah, thanks, yep.
Mr. Davis is here.
Anthony Davis?
Yeah, he's on Zoom. All right, Mr. Davis, we can call your case. You can unmute. Mr. Davis, you can unmute. He's having trouble unmuting. There you are. All right. All right, so we're on the record in docket 24-02467. That is People of the State of Michigan versus Anthony Davis. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Anthony Davis.
And sir, you are Anthony Davis, is that correct?
Yes, sir.
And you can hear me all right, Mr. Davis?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The offer in this matter is for the defendant to accept responsibility to a civil infraction of impeding traffic. I believe that's a fine of 135, if my memory
That sounds
serves.
right.
And I don't believe it comes with any points on the license.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
All right. And Mr. Davis, that's your understanding. You'll be through Mr. Lee, you'll be admitting responsibility to the civil infraction of impeding traffic.
Yes, sir.
Okay. And then there'll be a dismissal of the misdemeanor.
That's correct.
All right, Mr. Lee, so we're working from the same ticket. That would be the ticket 12361 at the offense location of, reading that, June 20th, 2024 at Grand Addernear Circle Drive in the city of Lansing, Ingham County. Do you accept responsibility on behalf of your client for the civil infraction of impeding traffic?
Yes, Your Honor.
And that comes with a fine of $135. Does Mr. Davis need some time to make that payment to the city of Lansing?
He would request 60 days, Your Honor.
So 60 days out.
February 14th.
It'll be February 14th. So, Mr. Davis, as long as $135 are paid by February 14th, you can set up your own payment plan with the city of Lansing, which is just as long as it's all paid by February 14th. All right, sir?
Yes, sir. Thank you.
And that can be paid online, in person, or at the counter.
Okay.
Anything else for the record in 2402467, Ms. Wilson?
Not for the people.
Mr. Lee.
No, thank you.
Mr. Davis, you're all set. Thank you for your appearance today.
Thank you.
Okay, sounds good. For the yeah, okay. Okay, sounds good. And then we're ready on Velasquez.
The last Tierra. I believe it. All right, so we're on the record in docket 2303070. That is people of the state of Michigan versus Tierra Velasquez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Tierra Velasquez.
And ma'am, you are Tierra Velasquez, is that correct?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter, final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Subpoenas did not go out in this. However, the people have been unable to make contact with the complainant since the initiation of the case. I expect a motion from the defense.
Mr. Lee.
Given that the prosecution is unable to proceed and the complaining witness is not cooperating, we would ask for a dismissal, Your Honor.
All right, I will, based on the defense motion to dismiss without prejudice and people having no contact with the complaining victim, people are unable to proceed today. We will dismiss without prejudice on docket 2303070. Ms. Velasquez, that means that the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, ma'am?
Sir.
All right. I'm going to sign the order, the nollie pros accordingly. And it would take about a day to make sure all of this is purged. Any of the pretrial conditions is purged from the system, all right? So just understand that it takes about a day. Anything else for the record in 2303070, Ms. Wilson?
Not for the people.
Mr. Lee.
Nothing further, Your Honor.
All right, Ms. Velasquez, you're all set. Thank you for your
Thank you.
appearance today.
Okay. Mhm. We're ready on Centeno?
Enrique?
Yes.
Don't seem to be able to. Blankenship. McKean. Pierce. Robinson. And then Cottenham. And then Terry. All right, so we're on the record in docket 22-01240. That's people of the state of Michigan versus Enrique Centeno. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Enrique Centeno.
And sir, you are Enrique Centeno, is that correct?
Enrique Eugene Centeno.
Thank you. This is the time set for a pretrial on the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. We're going to be requesting a final pretrial, and if we could get it after the first of the year, there is a hope to kind of wrap things up with a felony file that's pending as well.
All right, final pretrial after the first of the year.
Yeah.
Set for
January 7th and 8th.
January 7th. 8:30. Right, we'll set for January 7th at 8:30 for final pretrial. That'll be live on the 6th floor of City Hall of Lansing as we are now. Anything else for the record in docket 22-01240, Ms. Wilson?
Not for the people.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Centeno, we'll see you here on January 7th at 8:30. All right, sir?
Okay,
Thank you.
thank you.
And you should get notice from my courthouse.
Mr. Lee, if you could grab one copy.
We'll find out. All right, Mr. Maron, we'll call your case. You can unmute. So, Mr. Maron, you can unmute. Thank you.
I'm here.
So we're on the record in docket 24-02812 and the accompanying ticket of 24-0123121. That is the people of the state of Michigan versus Jose Maron. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Riley on behalf of Mr. Maron.
And sir, you are Jose Maron, is that correct?
Correct.
All right, you can hear me all right, Mr. Maron?
Yes, I can.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think we're going to be requesting a plea date.
And is that a full and fair statement, Mr. Raleigh?
Yes, sir.
All right, we'll set for plea.
January 7th at 9.
January 7th at 9 o'clock. So we've set for January 7th at 9 o'clock for plea. This is a traffic case and a ticket. Do you know, should we do this in person or by Zoom?
Either way is fine.
All right. So Zoom's appropriate if available. And is that a fair statement, Mr. Raleigh? It's January 7th at 9 and Zoom is appropriate if everyone's available, or they can show up live in person. It's up to the person. All right.
Sure.
Anything else for the record in 2402-812 or 240 or the accompanying ticket at 240123-121, Ms. Wilson?
Half of the people.
Mr. Raleigh.
Nothing from the defense.
All right, Mr. Maron, we've set it for plea on January 7th at 9 o'clock. Thank you for your appearance today.
Thank you. You guys have a good day. Good holiday.
You
too.
too. All right, Mr. Terry, we'll call your case. So we're on the record in 24-02745. 24-03265. 24-03532. And 24-03550. That's people of the state of Michigan versus Rodney Terry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Rodney Terry.
And sir, you are Rodney Terry, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Terry?
I can, yeah.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to be requesting adjournment after the first of the year. There are some new files that we're hoping to get a global resolution on.
All right. And is that that's a full statement, a full and fair statement, Mr. Lee?
Yes, Your Honor.
All right, so we'll adjourn after the first.
Is there any way?
And we'll adjourn to.
Your Honor, I've been sitting in jail for about 2 weeks. Is there any way I can get a PR?
No, we're waiting on other files. It looks like you've got 4 files here and some more coming. So we're adjourning in order for a global resolution to January 7th at 10 a.m.
I'm sorry, return, Your Honor. It's just I got some things I need to, work out the aftermath of from where I was living.
Yeah. Do you know how many other files are out there, Ms. Wilson?
So I know there are several that I've been holding off on charging in anticipation of a global. However, I do know that the new file that I was referencing is 3 counts of an RNO and a retail fraud that I believe is set for PCC in front of, I want to say, Judge Buchanan this
All right.
week.
So there's a pending felony file.
That's correct.
All right, so
It appears his bond on that is 5,010%.
all right. Did you want bond to be set on any of these
Your
files?
Honor, I think it would be appropriate for a bond to be set.
All right, so so that therefore, because I think it's 10, I think he's got 1 to 10%, the rest are PR bonds on these. So I'm gonna set them on all low 10%, yeah. So I think he's got So on 2403-265, it's $100, 10% on that one. That was set by the magistrate. I'll put them all at that, at that. So it's $100, 10%. On file 2403-532. Be $100, 10%. No PR.
Yeah.
Because we want him collecting all his time, because he's gonna be in on the felony.
We don't
Yeah.
know this PRM and four on these.
Whether we want to or not.
Yes.
Yeah, January 7th at 10.
All right, so as to files 2402-745, 2403-265, 24-03532, and 2403-550, those have all been adjourned to January 7th at 10 a.m. to coincide with at least one felony we know of coming from Judge Buchanan. Bond has been set at, they were mostly PR bonds, but that means that he wasn't collecting any time on them. So we've now set them at all at low 10%, $100, 10%. So if he chooses to, he can collect on any of these as part of, but the bond on the felony is set at 5,000.
10%.
So the defendant will still be hold on that felony bond. Anything else for the record in any one of these files? Ms. Wilson,
Not for the people.
Mr. Lee.
Nothing further, Your Honor.
All right, you're all set, Mr. Terry. Once this is combined with the new file, I'll see you on January 7th at 10 a.m. 24-01404. That is People of the State of Michigan versus Darren Cottenham. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Carter.
And please the court, David B. Carter Jr. on behalf of Mr. Cottenham, who is not present. I called the hall several times and he doesn't appear to be in the hallway.
All right, this is the time set for a pre-trial or PA 53 and pre-trial. It was scheduled for 9:30. It's now 9:58. Ms. Wilson, based on the representations of counsel, how did you want to proceed?
Thank you. I'll be requesting an immediate bench warrant and bond forfeiture. This is not Mr. Cottenham's first failure to appear, and this is an assault of offense.
I do have it as a June 10th of failed to appear, and it's a DV. Any comment, Mr. Carter?
I would just indicate that I got very short notice of this hearing and have not been able to make contact with them. So other than that, I have nothing more to say.
All right. We're into a bench warrant and bond forfeiture on the PA 53 and the domestic assault case. Anything else for the record in docket 24-01404, Ms. Wilson?
Not for the people.
Mr. Carter?
Not for the defense. Thank
All
you.
right, thank you. We're all set on that. And then I did finally meet Mr. Carter. All right, so we're on the record in docket 24-03521. That is people of the state of Michigan versus Andrew Blankenship. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
And Jacob Riley on behalf of Mr. Blankenship.
And this is the time set for a MDOP pre-trial, looks like 2 counts. So MDOP and domestic violence pre-trial. Thanks. This was scheduled for 9 o'clock. It is now 10:06. Mr. Raleigh, have you had any contact with Mr. Blankenship?
The last time I spoke to him, he was in custody, Your Honor, and I understand he was released on the 9th. I've not spoken to him since then.
All right. It would appear based on I do not see Andrew Blankenship in the Zoom courtroom, physical courtroom. His name has been called in the hallway. Ms. Wilson, how did you want to proceed?
Thank you, Your Honor. Considering that count 2 is an assaultive offense, I'd be requesting an immediate bench warrant.
All right, this is the first pretrial set, but count 2 is an assaulted pretrial coming out of a domestic violence. So based on the non-appearance, Mr. Blankenship, the court will issue a bench warrant and bond forfeiture on the matter. Anything else for the record? In docket 24-03521, Ms. Wilson.
Not for the people.
Mr. Raleigh.
No, Your Honor.
Okay. It would appear the defendant was using an alias during some other, at a bond recommendation hearing. So, all right. Because I have, as part of the bond recommendation, defendant has out-of-state ties, was using a different last name as well as an R&O, has an R&O and escape by convictions concerning some of these matters. So I'll issue a bench warrant and bond forfeiture. Anything else for the record? Or that's all for the record in 24-03521. Thank you, everybody, for your appearance.
And then I think we're good to call Pierce.
Oh, Pierce. Brittany Pierce. All right, so we're on the record in 24-02565. 24-02566. 24-02568. And 24-02569. That is people of the state of Michigan versus Brittany Pierce. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Riley on behalf of Ms. Pierce.
This is the time set for a plea in the matter. Ms. Wilson, how are we proceeding? It appear that this was scheduled for 9 o'clock. It is now 10:09. I don't see Ms. Pierce in the Zoom courtroom or the physical courtroom. Ms. Raleigh, have you had any contact with Ms. Pierce?
Actually, I'm just seeing now that I received a voicemail from her at 9:12 this morning. I've not listened to it yet, so I don't know what she has to say, but that's what I have for recent contact.
All right. This was set for plea today on the dog at large cases. Ms. Wilson, how did you want to proceed?
Given that there's a recent voicemail to Mr. Raleigh, I think a courtesy reset's fine.
All right.
That would be my request.
All right. So we'll reset the plea. We've had some contact, or there looks like there was some contact with Ms. Pierce, and we've reset for, we'll reset for
January 7th at 10.
January 7th at 10. So we'll reset 24-026, 2565, 2566, 2568, and 2569 for January 7th at 10 o'clock. Anything else for the record on any of those four files, Ms. Wilson?
Not for the people.
Mr. Raleigh?
No, Your Honor.
All right. We'll see everybody on January 7th at 10 o'clock.
And I think McKeon is the last one.
Yeah. Pierce was a plea on compliance, I thought. Can't remember.
No, it was a plea with maybe some compliance.
Okay, maybe. Okay.
Maybe.
And we'll call Jennifer McKeon. All right, so we're on the record in docket 24-03206. That is People of the State of Michigan versus Jennifer McKeon. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Jennifer McKeon.
This was set, this was a pretrial set for 9 o'clock. It is now 10:12. I do not see Ms. McKeon in the Zoom courtroom or the physical courtroom. Mr. Lee, have you had any contact with Ms. McKeon?
A while back, I had contact with her. Lately, when I've been calling her, her phone is saying that she's not accepting calls at this time.
All right.
I don't know. She made remediation efforts and was moving forward on the case. So maybe there's been some confusion or something that happened on her end. I don't.
I have, on December 2nd, she was failed to appear and we did a courtesy reset because I think there was some contact. But so we reset it for today's date. Ms. Wilson, how would you like to proceed?
Thank you, Your Honor. Given that there's a previous failure to appear, I'd be requesting a bench warrant with a 48-hour hold.
I think that's, yeah, we haven't seen her since November 19th. And then we confirmed the number on that date. So we didn't see her on the 2nd. So I'll issue a bench warrant and bond forfeiture with a 48-hour hold, just to hear from her. Anything else for the record in docket 24-03206, Mr. Lee?
Nothing further.
Ms. Wilson.
Not for the people.
All right, thank you for your appearance today. We should be all set. All right, Ms. Wilson, how are we starting today?
I believe we're ready on Oakwood.
Joseph. Right, and that's it for sentencing today?
Yes.
Right, so we're on the record in docket 24-02805. That is people of the state of Michigan versus Joseph Paul Oakwood. Would the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Joseph Oakwood.
And sir, you are Joseph Oakwood, is that correct?
Yes, sir.
Thank you. This is the time set for sentencing in the matter. Ms. Wilson, is there any restitution on this file?
There is not, Your Honor. However, the victim is interested in making a statement through our victim advocate who is present here today.
All right. And the victim is?
Jane Bogenauer.
She's online.
Yes, she's on Zoom.
All right, and then the statement will be made through the victim advocate, is that
Yep.
correct? All right.
Whenever the court's
All right.
ready. Yep.
And Mr. Lee, did you have the opportunity to go through the pre-sentence report with Mr. Oakwood?
I did, Your Honor.
Any additions, deletions, or corrections?
No additions, deletions, or corrections.
Okay, allocution of Mr. Lee.
Thank you, Your Honor. We would ask the court to consider that Mr. Oakwood has cooperated throughout this process. He, in fact, the interviewer in the pre-sentence investigation report noted that he was honest and sincere and took responsibility for what happened on this particular occasion. Mr. Oakwood is currently working full-time at Amazon and continues to be a father to the two children that are part of this relationship. He would ask that the court, if there is any no contact orders in place with the children, that the court amend that and allow contact and perhaps third-party contact with the mother to arrange for visitation, as that is something that is near and dear to his heart. Understanding. We think that the probation recommendations are on point. We would ask the court to adopt them, including the 769.4A status.
Thank you. On behalf of Ms. Bogenauer, any comment from the on behalf of the victim? And ma'am, please state your first name and last name for the record.
Jacqueline Ward,
Okay, and you should spell those just so we get them right.
JACQUELYN
All right, you may proceed, Ms. Ward.
I received this statement from the victim last week, and I'll be reading it for her. She's on Zoom.
Okay.
I'm not sure how to start this statement. I'm making on behalf of myself and our two children today, who aren't old enough to speak for themselves yet. I guess I'll start by saying this. The children I share with Mr. Oakwood were no accident. We had planned hand in hand to have a family that he has left behind due to his inability to hold himself accountable for his actions without manipulating everyone around him to think the mother of his children is what put him in the position he's in today. The truth is, I am not perfect, nor have I ever claimed to be. The difference between myself and Mr. Oakwood is that I can take accountability and be honest with myself. I am able to see my flaws and try to grow better and be a better version of myself. I can allow myself to be vulnerable. I have asked Mr. Oakwood for years to seek therapy and to get back on medications he so badly needs. After a traumatic car accident we were both in, it has affected him more than it did myself, and I knew that. I've always been sensitive about that for him. It has altered his life forever in more ways than one. However, he has a history of commitment, abandonment, and abusive issues and habits in every imaginable way, and it started prior to his life with me. He came into my life with promises he had no intentions of keeping, playing on my abandonment issues and PTSD from other traumatic experiences. I was open with him about the first month we met. He hasn't even acknowledged our children since I called 911 when he assaulted me, nearly leaving me unconscious. Pieces of my hair and scalp everywhere, bloody and blue body and face. Tomorrow would have been our 3-year anniversary. I never thought this is how we would be spending it. I have cried myself to sleep many nights since the assault. So have our children. Our children have regressed once again because of his actions. I can't even leave the room without our son screaming and crying and running after me because he's so scared another parent might be gone forever. My children no longer sleep through the night. They're confused and God knows what else. He left me with a lease we're both on until February. Foster animals, every utility bill, rent, food, and so much more, and he couldn't be less concerned. I have been scrambling to borrow money, take out loans, and keep my head above water and manage everything myself as a disabled woman who is now alone. Mr. Oakwood stole my debit card, my EBT card, my WIC card, and even went so far as to take my work key for the only job I had in walking distance for spare cash I needed throughout this time. I'm leaving home, and after weeks of begging for my personal items back, Mr. Oakwood decided when I was allowed to have them back, leaving the items outside for anyone to steal in the middle of the night with no warning when he felt like doing so. He also had the nerve to sit here in court at the last hearing and let his attorney lie on his behalf and tell the court on the record that I had shown up to his house, which is impossible since I don't drive. And at that time, he was still holding my kids' car seats hostage, so we had no way of leaving our home and still rarely do. He doesn't think of anyone else has feelings, boundaries, and deserves respect the way that he does and shows. Everything is always on his terms and time. Today, I'm asking you that you do not simply slap him on the wrist for his first offense. This was just the first time I finally had the nerve to report it because I know our kids are getting older and I refuse to let them grow up in a toxic environment where there is violence and yelling every day. I'm asking the court to consider the weeks of battery prevention classes that are in person, parenting classes, anger management classes, and drug and alcohol testing while he's on his probation. Everything has always seemed like a joke to Mr. Oakwood, and I am in no way trying to seek vengeance on this man that gave me a family and was once the love of my life. I am hoping with these conditions, he takes a deeper look into himself and really does some soul searching. I know he's capable of being better. I think he's gotten comfortable doing the opposite for so long as he is the side of his friends and family believes he's done nothing wrong. I hope one day I can trust him to be around our children again, but I need him to prove himself to us, the family he abused and left behind, if he ever wants to be in our children's life again. I'm sorry this is how our anniversary was spent. Are you? I'm sorry you missed your son's first steps and your daughter's second birthday. Are you? Even if you never want to see us again, you need to be held accountable for once and not be let off the hook so lightly so this pattern of abuse ends with us. No one deserves what we have endured. I also wanted to ask that he hand the pistol into authority and not simply with a friend or family he's living with. That in no way makes me feel safe or ensures he will not get it in his hands. Thank you for taking the time to listen to the statement today.
In regards to the contact with the children, there's right now, there's a no contact with Jane Vogenauer, or to be within 2,000 feet where the victim lives, works, goes to school. There's nothing in relation to the children, Ms. Wilson.
That's correct, Your Honor. It's my understanding that there's a family court process ongoing right now. At this time, I would request that there be some kind of order from the family court regarding parenting time. And before we allow third-party contact for the purposes of the children, just so everybody's bases are covered and there's some kind of court order that states when and where parenting time is going to happen. Otherwise, I feel like we're just going to run into an issue.
So it would be the practice of the court to follow any orders that are put down in regards to visitation from family court. All right. Mr. Lee, anything in response?
I completely agree, Your Honor. The family court is the best place to resolve those types of issues. There is not, I think the court just noted a no contact order in place with the children. This was an incident between the adults. And so that's the reason we asked for the third party. If the court doesn't want to grant a third party, we understand. We would just ask then that it not add a no contact order and let the family court resolve it.
I'm going to leave it to the family court as far as any third party contact with the children. But you have a no contact order with the victim. And until they get that all worked out in family court, I would suspect that it's no contact with the minor children until third party contact is arranged or something along those lines. But I'm gonna follow it as a domestic violence case and not going to invade the province of the family court. Mr. Oakwood, is there anything you'd like to say to the court before the court passes sentence?
I got no comment.
Okay. All right. It appears that there was a killabrew of no upfront jail that I will follow. There was a no objection for 769 4A status that I will also follow. This is for the guilty plea on October 10th, 2024 in regards to domestic violence. It is determined by the court that you spend 93 days in jail, credits given for 2 days previously served. So suspend the following 91 days upon successful completion of probation. All right, so I'm changing that just because there's a typo. There's also a typo on your name, but we can address that. Fines and costs. We'll make the $200 fine, $200 costs. Crime victims' rights fee of $75. State minimum cost fee of $50. I'm placing you on probation for 9 months at $30 a month. So that would be 30 times 9 equals 270. I'll give you a grand total. That's 400 plus 75 plus 50 plus 270. So that's a total of $795. Your 769 4A is granted at this point in time with the successful completions of the 9 months probation. No contact with the victim, Jane Vogenauer, or be within 2,000 feet of where the victim lives, works, goes to school without consent of this court. And then that can be modified once the family court figures out their third party notification. But that is the typical sentence for no contact order in DV concerning a domestic violence. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, no bars or nightclubs. I'm going to complete following rehabilitative services, pay fees, and provide proof of completion of the court. You should, at the request of your probation agent, the domestic abuse rehabilitative services class, whatever class they recommend, and the anger management group is also part of the 9 months completion of the court. Not purchase or possess firearms, ammunitions, or weapons of any kind, and then follow any family court orders that are set down in relation to this file. So it's 9 months probation. I can tell you what usually violates people's probation, and that's they test or drop dirty. I'm going to be placing considerable amount of attention to whether and when you timely complete the domestic abuse and anger management training. Okay, those I think can be very helpful. Okay, if you're able to do that, then I can see that things are starting to turn around a little bit. All right. Anything towards the judgment of sentence, Ms. Wilson?
A couple things, Your Honor. In regards to the firearms, I know that Mr. Oakwood currently has a pistol that is registered to him. Is the court ordering that be turned over to law enforcement for the duration of the probation? Or what do we want to do with that?
He has to turn it over to somebody who won't turn it back to him.
Okay.
Okay. The order of the court is not purchase, possess firearms, ammunitions, or weapons of any kind. And so I would think that has to be immediate, but it can't be returned to him under the conditions of probation. So for the next 9 months.
Okay.
I don't think that, I think that can, that places whoever he puts it in the possession of to be responsible for your conduct, which means that if you do something assaultive in relation to that, they're also placed in a position that they can also look at that and be charged with that. So you want to give it, you want to make sure that it's not in your possession, given to somebody who keeps it from you for 9 months, or you put yourself at issue. Okay.
It's not gonna be an issue.
Okay. All right. Just as long as you know, everyone says that. So let's just keep it. Let's just keep it. Yeah. It's exactly what everybody says. And I just want to make sure I want to make sure that everybody's safe and gets to go home. Okay. All right. So for 9 months, that goes to someone else. After probation, I don't have jurisdiction.
Right,
Anything else?
Just for clarity purposes, I think there may be an order from the family court in place right now, but I don't have it. So if there is currently parenting time ordered, then that order would need to be supplied to probation.
Yeah. And I think probation should be caught up on any type of, because what's going to happen is there may be third-party contact in relation to Ms. Vogenauer, and that should be deemed by the family court. This no contact order is ongoing unless that's superseded by the family court on some level. Okay.
Can I speak?
You can.
Oh, okay, sorry. Yeah, so I was recently awarded full sole custody of both children until he finishes his parenting classes.
All right. Well, if that's the order of the family court, that's the order that we follow.
Okay.
Yeah, that's the order of the court was to follow all and any family court orders.
Okay.
So now that may change depending on what the family court does, and so, but you still are under a no contact order and no third party contact unless the family court orders it. Then you may be reached. But as far as this file goes, the defendant shouldn't be having any contact with you.
Okay.
All right. Turn over firearm to another person for the sole of the 9 months in probation, and it shouldn't be returned during the probationary term. Those are the 9 months I've placed. Anything else towards the record in docket 2402805, Mr. Lee?
Just to be clear, Your Honor, did you sentence him to 9 months probation or 6?
9.
Okay.
Yeah, 9.
Sorry,
I added 3 months in order for the somewhat to make it easier to complete anger management and the added domestic abuse. I've put 2, and then there is the terms of probation. But most of all, family court's going to have its own orders, and we want to make sure that that's all covered. Not only an extension. This court, we only have, as you know, we only have jurisdiction over the domestic violence, and I think this goes a little further than that with the children and what have you. Mr. Oakwood, do you have any questions concerning the judgment sentence of the court?
No questions.
All right. Go down and see your probation. I don't know who your probation officer is. I don't know who wrote the report. I can look here.
I think it was Mr. Hannah.
So is Brendan Hanna. I know Mr. Hanna. Mr. Hanna is a pretty flexible person. He's easy to work with. So Mr. Hanna starts coming to me with probation violations. Something's not gone right. Okay, something's not gone right because he's pretty easy to get along with. So for the next 9 months, Mr. Oakwood, I'm not worried about you for the next 9 months. I know where you're going to be. All right, and I also know that if you don't do what you're supposed to, we're going to put you in jail. Okay, it's a horrible concept. It's not one that anybody learns from, but it's a concept we have. Okay, what I'm worried about and what I'm really reaching for is the next 5 years from now, where you're making independent decisions, and they all have to be effective and good decisions. Mostly because you're a parent. All right, so take this process to learn from this process. Okay, if you don't, then we're back here 5 years from now. And we're going through the same thing with children 5 years older, and we are really looking at limiting our options at that point. Okay, so for all our sakes, including yours, learn from this. Okay, learn from this arena. All right, you should go down and see Mr. Han on the 5th floor just to make sure you're on the same page, and then and he's the one who will be talking to me. All right. All right. Anything else for the record, Mr. Oakwood?
Nothing. I just hope you have a good day.
All right. Right. That's all for the record in 2402805. Thank you, everybody, for your appearance today.
Thank you.
Do we need that victim on?
Sorry.
We want that victim on the sheet in the file.
It's part of the transcript. Did you want that, the victim impact statement in the file? Because we can put it in with the probation. It's part of the actual transcript.
Yeah, I was gonna say, I added it to our file
Okay,
in our
perfect.
notes.
All right.
I mean, might as well just.
Yeah,
keep
so
it.
let's put it in the sentencing. That's a good idea. And then we have the transcript, but they have the actual. I mean, I'll let Megan put it in there. And I'm gonna put the judgment of sentence in the one I don't think it belongs in. That's the way I hopefully, the way we keep it in the one it belongs in. All right, anything else, Miss Wilson?
Mr. Rowley. Okay. Okay. We're ready on Harriman.
On Amanda Harriman, which is a pretrial.
It is going to be a plea.
All right. All right, so we're on the record in docket 24-00032. That is the people of the state of Michigan versus Amanda Harriman. Appearances for the record from the people.
Gabrielle Ezel for the people.
And it's Ezel, right?
Yes, Your Honor.
How's it spelled?
Ezell.
It's spelled the way it sounds.
Number.
What's that? Ezell, and what's your P number for the court reporter?
87868.
You're gonna be saying that forever. It's so true. We all remember our P number. Mr. Raleigh, your appearance for the record.
I'm Jacob Raleigh on behalf of Ms. Harriman.
All right, and ma'am, you are Amanda Harriman, is that correct? All right, thank you. This is the time set. I have it set for a pretrial and a PA 53 violation. Mrs. L, how are we proceeding?
Your Honor, the people are offering a plea deal to the defendant today. We are offering a plea for count 1 with a recommendation of 7694A and no upfront jail time.
So it's plea to the count 1 of the domestic violence. And Killebrew of no upfront jail. And no objection to 769-4A. All right. That DV is 93 and or 500. Is that a full and fair statement, Mr. Raleigh?
It is. I do want to just clarify. Would the people also be recommending dismissal of the violations?
Yes.
Okay, so that's a good. So not part and parcel of this plea agreement, but as a part of the PA 53 violation is going to be dismissed. And is that your understanding, Ms. Harriman?
Yes, sir.
All right. Mr. Raleigh may inquire of your client of their misdemeanor advice of rights concerning the misdemeanor plea.
Yes, sir.
All right, Ms. Harriman, you understand that the possible penalty of this case is 93 days and or $500. You understand that?
Yes, sir.
There's an agreement between the attorneys that you serve no upfront jail and that there's no objection to 769-4A status. As to the no upfront jail, if I was going to do something different, you'd have the opportunity to withdraw your plea. Do you understand that? Is that a yes?
Well, yes,
All right.
I'm sorry.
Right. So Mr. Raleigh's agreed with Mrs. L that you'd have you'd have the possibility to withdraw your plea if I did something different.
Correct.
You'd also there's no objection 769-4A status. Do you understand that, ma'am?
I don't understand the numbers, but I kind of.
All right. That's kind of the carrot here. If you get 769-4A status, there's some and you complete your probation successfully, that means that it's not abstracted as a conviction, which is what you want ultimately.
Right.
All right. Okay.
Thank you.
You have the following rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, the questioning witnesses that are brought against you. You are represented today by attorney Jacob Raleigh, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You're also giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish today to waive your jury trial rights and plead guilty to the domestic violence count?
Yes, sir.
All right. Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention, ma'am, back to January 4th of 2024 at the offense location of 811 West Lapeer Street in the city of Lansing, Ingham County. Were you at 811 West Lapeer Street in the city of Lansing, Ingham County on January 4th, 2024?
There I was.
And who is James David Harriman to you?
My husband.
All right. And at that time, what you're admitting to is offensively touching or attempting to offensively touch Mr. Harriman, and it wasn't done in self-defense or accident. Can you tell me what you did?
Yeah, I put myself in between two men and played referee, but when he got too close, I did push him away.
Okay.
So he didn't, he got loud and got my face. He didn't touch me. I was the first one.
All right. And he didn't want to be pushed.
Correct.
Okay. And you didn't do so in self-defense.
No, it wasn't self-defense.
Okay.
He just coming at me loud with words. So yeah.
And you didn't touch him in accident. You didn't accidentally touch him.
No, I purposely
You
needed him
meant to
away.
push him.
So, right, yes, sir.
Anything towards a factual basis, Mrs. L.
No, Your Honor.
Mr. Raleigh.
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. And so that would be a plea to count one. And we will refer to probation. What they're going to be looking at probation, they do a report for me. And what they're really is looking at that 769-4A status to make sure you're eligible for that. And they'll consider the no front jail, but we'll refer to probation. So after we're done here, go to the 5th floor. That's where the probation department is, and find out. They may see you now, or they might set up an appointment, but that's when you want to see them.
Gotcha.
And then we'll set the sentencing date for
February 11th at 1:30.
February 11th at 1:30. All right. All right, so we've set the sentencing date for February 11th at 1:30. Go down to the 5th floor. Anything else for the record on 24-00032, Mrs. L?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Ms. Harriman, we'll see you on that February 11th date. Thank you for your
Appreciate
appearance
you
today.
guys.
Oh, perfect.
It's perfect.
Delaney Nichols.
Lady Nichols? All right,
That's a sentencing.
all right, Miss Nichols. All right, so we're on the record in docket 1704868. That's people of the state of Michigan versus Delina Elaine Nichols. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Riley on behalf of Ms. Nichols.
All right, and ma'am, you are Delina Elaine Nichols?
Elaine Nichols.
All right, thank you. This is the time set for a probation. This is a sentencing. And I do have an updated, this was done in February 7th of 2018. That's the last updated pre-sentence. Do you have that?
We don't.
Did you want to look at that?
Yes, please.
All right. I'll provide it to both counsel to look at. That's the last thing I have is from the probation officer. on this is a 2018 case. And yet you can share that with Mr. Raleigh. So with the most recent sentencing assessment of 2018, I'm a little reluctant to go forward with the sentencing, obviously. I think both parties can understand why. I mean, it's been since 2018 since we've had a report done. The defendant failed to appear as of February 2018. That's here. Yeah, that's. Yeah, that doesn't tell me anything. Tells me that Battle Creek has one issue on October of 2017. And the rest of it is the rest of it's pre-2018. I don't know, what do you have, Ms. Wilson? Do you have anything that?
I don't have an updated one. I'm looking right now on the, what's it called? My Court to see if it says anything.
Right. So I think we need an updated report. That's because the request from the 2018 was a year in jail. That was a request. Okay. Now a lot's happened in 6 years. All right. But I don't know that. I have this report and that was done 6 years ago. And so I think it's to everybody's advantage that we find out what's been going on for 6 years. Here's the problem I have, Ms. Nichols, and that being completely straightforward, if I have you go and talk to probation so they can do a report for me, what I'm essentially saying is that you are out and you can stay out, and we lost track of you for 6 years. I mean, I don't have anything until that you failed to appear in 2018.
That was supposed to be in probation?
You have to be someplace. I mean, you got to be someplace, right? You know, I mean, you got to be connected to the court someplace. That's my fear here. My fear here is that we lost you for 6 years. I can't lose you for another 6 years, you know, and they're recommending a year in jail, and we haven't seen you in 6 years. And so, but you showed up today, I'll give you credit, you know, because I'm not sure you knew what you were facing and you showed up. Okay. You knew you failed to appear 6 years ago. You show up for sentencing today. I see from the abstract, from the sentencing abstract, it appears that the only thing that you've been in since 2018 trouble is from Battle Creek, but I don't know that because I don't know if you've been out of state, or I don't know. So it's not always abstracted, but I do have an abstract from Battle Creek, but that's in 2024. And I don't have any conviction associated with that. So obviously I have some questions, but the real question is, do we leave you out to talk to probation after we lost you for 6 years? But and I'll hear arguments on either side. All right. So Mr. Raleigh.
Where I do want to note that my client does have a pending matter in Calhoun County at Battle Creek, and she has been attending regular court dates and participating in that case. So certainly she has every incentive to remain in compliance and remain in contact with the court and come to her court dates going forward. I guess that would be my argument in favor of allowing her to remain out until her next court date here.
All right. I have to comment on this. You were given a 10% bond. You failed to appear for 6 years, and the magistrate gives you a 10% bond, actually a lesser bond than what you previously had. That's kind of shocking to me, you know?
Okay. I'm just telling where I've been.
So, Your Honor, just for clarity purposes, looking at the register of actions in Calhoun County, it looks like she was sentenced to 30 days on January 12th. And then this sentencing was scheduled for February 27th. So I believe she would have been out about 15 days at that point. I don't know if there was maybe a mix up or what have you, but obviously she was aware that this case was happening. So I think that's kind of where we're at.
Well, it's just, it is, yeah, that's kind of where we're at. Mr. Raleigh, can you enlighten the court? Because I'm somewhat at a loss at for I can understand why a new pre-sentence wasn't done. I completely understand that, but B, and I know, and Ms. Nichols has shown up to court today, but I don't know if they were aware of the prior, the request was a year in the county, and then 6 years gone, and now we're trying to figure out what to do. And we have 6 years to kind of try to figure out. So, Mr. Raleigh, do you have any indication other than well, and it's not fair, but I guess we're going to find out. Do you have any indication from your client as to where she's been for 6 years?
I was in Lansing for 12 years. I was summoned to come home because my grandmother got sick. My mom had a stroke. I came home in 2017. When the incident happened in February, I did not know that I had a warrant until I was arrested this past October the 5th, where I had prior charges, old charges. Okay, so in the process that my mother, my grandmother, her brother, her 2 sisters, and my niece drowned 8 years. In his past 3 years. I didn't know I had a warrant here.
You knew you pled.
I don't even remember.
You pled to the charge, Kilabruno up from jail on January 8th.
I understand that, but I didn't know that I had a warrant. I knew I had other warrants. And I'm so glad I had 4 different warrants. I went to 4 different counties from October the 5th. I was incarcerated from October the 5th to October 31st. I'm pending to have probation. Each time we go to court, they keep adjourning it because whatever they don't have. It was from January, it was November 21st and then January 9th. Now it's pushed up to February 23rd in Calhoun County and sentences for probation, but I haven't went to the sentencing yet, but I do go to the pre-trials. I check in with pre-trial services. They got me for the summer point for behavior and substance abuse. And this is from a record of my past, and I'm trying to get it together for everything in the past, and I'm so glad, as long as I ever spent in jail 34 days, I am so glad not to be looking over my head. You know, I've been gone, having warrants so many years, but I was not aware of this warrant here in Lansing.
Yeah.
Until October the 5th when I was picked up.
So it does look like the Calhoun matter is 3 felony counts.
Felony counts. This is a retail fraud, but it's a sentencing and it's been gone for 6 years. I'm gonna do what I'm famous for, okay? What we're gonna split it, okay? So this bond is too low as far as I'm concerned, okay? But you do deserve some credit for showing up today, okay? Because it's been 6 years that we didn't have anything for you, but there's a reason why we don't have a pre-sentence report, and it's because we haven't seen you for a pre-sentence report at all. So I'm going to adjourn for pre-sentence for an updated pre-sentence report. So we'll adjourn for updated PSI. And we'll adjourn to, we probably need a regular sentencing date. in order to get the full probation and the full picture. Because right now you're kind of fighting uphill, okay? The previous 2018 was to terminate the Killebrew agreement, which is no upfront jail, and to say that you do a year in the county, okay? Now, that was 6 years ago. I don't know what's happened in the last 6 years, so we're gonna find out, all right? So I'm adjourned for updated pre-sentence investigation, and the sentencing date of
February 11th.
February 11th at 1:30. Now, all that's pretty academic. Or now we got to consider bond, all right? Generally, in this instance, I would remand you, okay? I just remand you to jail so that I know where you're gonna be, because I haven't seen you in 6 years, all right? But you showed up today, all right? And you've got another full thing going in Calhoun County. I'm not sure what that is, but it's a problem, okay? So I'm going to reset your bond for today. You're gonna go with my court officer, Ms. Slabiak, all right? Bond was initially set on this file at 3,010%, which you must have made because you were let out. And then they reset your bond when you came back on November 1st. The magistrate set it at 2,010%, which I think is dreadfully low for somebody who's been gone for 6 years, all right? So I'm going to set it at 5,010%. So the probation department may be down to see you, or if you're out, you can be out to see them. But they're going to prepare a report for February 11th at 1:30, and that's when I'll see you in order to figure out what we've been doing for 6 years. Because right now, I can't make a decision on that because I really don't know. I really don't know. All right. Anything towards the adjournment or judgment of sentence? So we're adjourning this judgment of sentence that was scheduled. It was initially scheduled in 2018. It's now December of 2024. I have a failed to appear as of February of 2018. And then it was referred for sentencing in November of 2024 to this. And then that's when the magistrate rearranged. Anything towards that adjournment, Ms. Wilson?
No, Your Honor, thank you.
Mr. Rowley?
No, Your Honor, thank you.
All right, Ms. Nichols, you can go with my court officer and I'll see you on I'll see you February 11th. Unless you're able to make bond, which is possible. It's not, it's a
So
bond.
you said I gotta pay bond before I leave
Well, it's 5,010%, so you'd have to come up with $500
today?
today.
I don't have it.
All right, then you can go in the Slaviak. That's all for the record. Thank you for your
They
appearance
said the
today.
bond, they only did 7 days and they let me out.
There's no PR bond on it. You're right. She'll be back.
I was getting ready to hand that back to you. I was just working through my stuff.
So that's all for the record in that file. I don't know if Mr. Marimba has joined us.
I thought we had him on earlier.
Hello.
Yeah.
So, Mr. Marimba, we're going to call you. We're going to call your case last.
My first name is
I have a. So let's call on. At 23-02017. That is people of the state of Michigan versus, I'm sorry, 24 00481. That's people of the state of Michigan versus Christopher Phillips. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
And Jacob Raleigh on behalf of Mr. Phillips.
And sir, you are Christopher Phillips, is that correct? All right, thank you. This is the time set for, I have it set for a plea today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a no contest plea to the charge with a sentencing agreement to fines, cost, and forfeiture of the weapon.
That is accurate. No.
Fines and cost and forfeiture of weapon. All right, so it's my understanding this is a plea of no contest to the charge of count one, fine, with an agreement of Killebrew no jail or no upfront jail, and then fines and costs and forfeiture of weapon. Is that correct?
That's correct.
And is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
Okay. And what are we using as a factual basis for the no contest?
Did you want to get my relates first? Your Honor, we have LPD report number 23519100006, and I have highlighted it with the factual basis and shared it with the defense.
All right. All right, Mr. Raleigh, may I inquire of Mr. Phillips of his advice of rights concerning the no contest plea?
Yes, Your Honor.
Mr. Phillips, you understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to questioning witnesses that are brought against you. You're represented today by Attorney Jacob Raleigh, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? You have the right to have the court order any witnesses appear in your defense to remain silent during trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you'll give the claim that the no contest plea was a result of any promises other than what we placed on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading no contest instead. Is it your intent today still to plead no contest to the charge? Okay. And I'm, as indicated previously, I'm go ahead, Ms.
I'm sorry, I might have missed it. Did we give the reason for the no contest?
We didn't. So what is the reason for the no contest plea?
The intoxication at the time of the incident.
So intoxication or lack of memory. Thank you, Ms. Wilson. All right, and in that regard, I am, as previously indicated, we're using as the no contest factual basis, the case number 23519100006 that was provided to me from the prosecutor. Ms. Raleigh, you've had the opportunity to at least see the highlighted portion of this.
Yes, Your Honor.
All right. So this is for conduct which occurred on October 8th, 2023 at the offense location of 805 Wisconsin Avenue, the city of Lansing, Ingham County, pursuant to the LPD report. It would appear that Mr. Phillips provided consent to search his vehicle, and the officer found what's commonly referred to as a ghost gun, but it was a firearm with the serial number engraved on the side of the frame, and it would not be able to be registered without a serial number, of course. It was a fully functioning firearm. It was a Glock style metal plate underneath the muzzle with a serial number would be engraved with no serial number on it. Anything towards the factual basis for the no contest plea, Ms. Wilson?
I think if the court can just make an inference that based on the lack of serial number, the gun was in fact not registered.
Well, the gun isn't registered because there was a lack of serial number, and there's been there's no contesting of the charge that Mr. Phillips was not aware that the gun was in the motor vehicle.
That's correct.
Is that a fair statement, Mr. Raleigh?
Yes, sir.
All right. So with that, I think that the no contest is for the factual basis that have indicated that essentially a ghost gun was located in the vehicle. Anything towards the factual basis, Mr. Raleigh?
I know, Your Honor. I do want to make it clear that my client did have a valid CPL, so mere possession of a firearm was not an issue. It was
Right.
the lack of the licensing of the firearm.
It was really the lack of the serial number on the firearm. Okay. So I find the no contest plea to be full, fair, and accurate concerning the factual basis of the purchase or possess, carry, transport without a license, because the gun was not able to be licensed. The misdemeanor charge has been met. Anything towards immediate sentencing, Ms. Wilson, or do we want to refer to probation?
No objection to immediate sentencing.
No objection from the defense.
All right. All right, I will follow the Killebrew agreement and indicate that there are fines and costs associated with this activity. We'll set fine at so this is a 90-day and or $100 fine and cost. Is that correct?
That's correct.
All right. So $50 fine, $50 costs for $100 in fines and costs. Crime victims' rights fee of $75, state fee of $50, for a grand total of $225. Also part of this is that the weapon will be forfeited. It is a misdemeanor, so for your CCW, there'll be a misdemeanor on your record. Okay, for the CPL that goes towards whether you can carry, possess. That'll be part of this. That'll be abstracted, and I think you should be aware of that. I don't do that, but it just happens as a part of the process. So does your client need some time to make that payment of $225 to the city of Lansing?
If you could have a couple of weeks, I think that would be enough.
So 2 weeks from today's date.
30th.
So let's do the beginning of the year.
January 6th.
Okay, so January 6th. So you'll have till January 6th to pay off the $225 fine for the essentially it's an improper registration charge. Okay, which you pled to. So it'll be a misdemeanor on your record, and the abstract will go towards your current CPL license. I think you should be aware of that. Anything else for the record in 2400481, Ms. Wilson?
Not for the people.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Phillips, you can pay online, in person, or at the counter. You have till January 6, 2025 to make that $225 payment. That'll keep you out of the show cause bench cycle. All right, sir? You're all set. Thank you for your appearance today. Then I'm going to return the LPD report.
Mr. Riley, if you could have your client wait a moment, we have paperwork.
They're just gonna give you some papers.
Most of it's on the payment, I think. And then, did you want the
Oh, yes.
report?
And then do we want to do the Marimbaya
Yes.
arraignment before?
Let's do
Yeah.
Mr. Marimbia.
Should I go down and jump online? I know you don't need me for the hearing, but he's gonna want to apply
Oh, yeah, that's probably a good
Go jump
idea.
online and
Yeah.
that'll give you, that'll mean he can do it instantly.
Mr. Riley, if you want to grab that judgment for judge to sign, this is the payment reminder for your client. Print. Oh, thank you.
Is that the judgment sentence?
Yeah, I whipped one up because I really wasn't sure.
But it came on a, it's
And
not a
then-
ticket.
Yeah, and then Mr. Riley's client has the fee schedule.
Oh.
See that, Mr. Riley, so thank you. You're very helpful, thank you.
All right, Mr. Marembia, we're here on docket 24-00130. This is the arraignment for Asanga Maremba, and sir, you are Asanga Maremba, is that correct? You'll have to unmute.
Yes.
Okay. This is time set for a probation violation arraignment. And it is alleged from probation officer from October 31st that you did consume alcohol on or around October 19th, according to the Charlotte Police Department, which is in technical violation of your probation. Let's see if there's anything, there's none others. Do you understand the nature of the probation violation, Mr. Maremba?
Yes.
All right, you understand you have a right to hearing in this matter, and you have the right to counsel. That you were previously represented by the Public Defender's Office on this file. It's my understanding you're going to seek additional representation from the Public Defender's Office on this file at this hearing. Is that correct?
Yes.
All right, and I'm going to let in, I'll let everybody in. There's all the civil, but Mr. Lee is here. And I'm going to place you, after we set this hearing, I'm going to place you in a room with Mr. Lee so Mr. Lee can take a financial application to that office. All right, sir?
All right.
He's right here. And so we will set it for probation violation hearing.
January 2nd at 9 o'clock.
For January 2nd at 9 o'clock. And your intent is to be represented by the Public Defender's Office at that hearing at that time. And I'm going to place you in a room with Mr. Lee. Mr. Lee, that hearing is set for January 2nd at 9 o'clock, just so you know. I'm going to place you in a room with Mr. Asanga so you can make financial application to your office. All right, sir?
Thank you, Your Honor.
All right. So, Mr. Asanga, you will get a prompt to go to room 1. Once you're done talking to Mr. Lee, you're excused from your until January 2nd. All right, sir?
All right. Sounds good. Thank you.
All right. So you're in room 1. And Mr. Lee, I'll also place you in room 1.
Thank you.
And then Gilchrist is non-public.
Correct. I believe Mr. Raleigh is on that, but he stepped out.
All right. Let's see. I don't want to start anything civil till we get done with that. I'm going to put everybody in this who's here for civil in a waiting room, in the waiting room. All right. All right. So Mr. Popoff, Sean Bodine, Tim Smith. What I'm going to do is we have one last criminal hearing that is non-public. So I'm going to go ahead and place you in the waiting room. We'll do that, and then I'll bring you in for all the civil stuff that we're going to follow up on. I think that's a 2:30 docket. All right.
Sounds good, John. Thank you.
All right.
Marianne Gilchrist.
And then if anybody's here who's not here on the Gilchrist matter, you should step outside except for the attorneys. I know the attorneys may be here. Is Mr. Gilchrist here?
Yes.
Okay. So if he's here for you, he can stay. All right. All right. It's really the closing the courtroom is for your protection. So, all right. All right. So we're on the record in docket 23-02017. That is People of the State of Michigan versus Jovan Gilchrist. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Riley on behalf of Mr. Gilchrist.
And sir, you are Jovan Gilchrist, is that correct? All right, thank you. This is the time set for a probation violation hearing.
Oh, Your Honor, can we mute?
Yes.
Hello? Hello?
Hey Gabby, did you try? No. I was hoping you would give me a right back. Oh, yeah, no, I won't.
Hello?
Mrs. L, it's Azel's your last name, right?
Yes,
Mrs. L, thank you for your appearance today.
thank you.
Mr. Raleigh, thanks for your help. All right, let's see. I'm gonna pull up the civil docket that I have, and some of this I have. We just got done with the criminal docket. Oh, there it is right there. So we can go in order here. So I have. This is- Well, that judge is yelling at somebody. That's not me. I'm not doing that. So I have a Lafque versus Christian Black. Are you Christian Black?
No, we put Delina Nichols.
Delina Nichols is
In jail.
in Ingham County Jail at this time. She's been incarcerated, so you should probably go down, I'd say probably she's probably in LPD lockup right now, yes.
She locked up right now?
Well, she was put on bond, and I don't know if she's able to make bond or not.
You know, what is, you don't know.
I know what the bond is. It's 5,000, 10%. So it's $500. Okay. All right. So I have a docket 1800162 GC. I have a paper file.
Okay, I'm sorry.
I also have an on-base file that I'm going to ignore gladly. That's Lafque versus Christian Black. Will the parties please introduce themselves for the record? Mr. Smith from Lafque.
For Lafque, Tim Smith, 48259. Good afternoon, Your Honor.
Good afternoon, Mr. Smith. I thought this was a motion. Was this a motion for show cause on Ms. Black?
Correct. We had a prior creditor examination. There were documents, though, that were responsive to your subpoena or the court subpoena relating to an employment situation as well as a banking situation. We had sent her what we call a reminder letter after the hearing. Here's what you need to produce. Here's where you got to send it. We haven't received any of the documents.
Right. And I do have that we attempted from the court to give her notice of, well, that's on August. So let's see. I don't think, no, we just did the letter.
This was notice for today was, as typical with the motions to show cause, was 9-day mailing.
Right. Yeah, good. All right.
It gave her the option to appear in person and the Zoom information as well, Your Honor.
Right. So, Mr. Smith, how did you want to proceed today?
Really no choice.
Because it would appear that Miss Black is not here. This is scheduled for 2:30. It's now 2:58, and she's not in the Zoom courtroom or physical courtroom. How did you want to proceed? And I know you've been more than patient in this matter.
No, that's quite all right, Your Honor. I'm gonna extend a little more patience in this regard. What I'm gonna do is, because I don't have a good phone number in my file, I'm gonna get in writing to her today about her failure to appear. If I can't get a response in the next 7 days, we'll submit a warrant, Your Honor, for bond consideration purposes. The balance today, $12,086.80.
All right, I will await the order to follow signing, but that'll give you some time to update the address and try to contact Ms. Black at that time. But I'll await the order to follow for the non-appearance.
Perfect. Thanks
and for the show cause.
Correct. And then, just so that we're clear, if I don't hear back from her, we'll be submitting the warrant for failing to appear today, correct?
Right. All right. Okay. All right. Anything else for the record in 1800162, Mr. Smith?
Nothing, Your Honor. Thank you.
Thank you. You're all set. All right, so we're on the record in docket 22-01605. That's Credit Acceptance Corporation versus Ulysses Allen. Will the parties please introduce themselves for the record from Credit Acceptance Corporation?
Good afternoon, Judge Alexander Popoff, PA 4378, appearing on behalf of the plaintiff.
All right, and sir, you are Ulysses Allen, is that correct?
Yes, sir.
All right, thank you. This is a response to your motion for installments payments, Mr. Allen. And is that a fair statement, Mr. Popoff?
That's right, Judge.
All right. Mr. Popoff, did you want the opportunity to speak with Mr. Allen, or did you want to go ahead and voice your objections to the motion? This is a motion for the order to amend the order installment payments to $50 a month. Is that my understanding?
Yeah, that's.
And then I was able to read your response, your written response, which would indicate, and you indicate in your response that that doesn't cover the interest involved.
That's correct, Your Honor.
Okay. Did you want the opportunity to speak with Mr. Allen, or did you want to go ahead and, because I can put you in a breakout room to see if there's any meeting ground, or we can go forward?
I think we can just go forward today, Judge.
All right. So, Mr. Popoff, one of the indications is that the installment payment requested of Mr. Allen, $50 a month, his proposal fails to cover the monthly interest rate. The actual balance started at $15,457 and is now at $19,549, and that you're requesting a payment in the realm of $600 a month, which is a far cry from the $50 a month. Is that a fair statement?
Yeah, Judge. The judgment is from 2023. It's continuing to accrue interest. We're at about $19,445 now. And we're willing to work with him, but $50 a month really wouldn't help his situation at all, or my client.
Mr. Allen, any response?
Yes, sir, Your Honor. I'm already paying an installment of $50 to another credit acceptance thing. I'm strapped, man. I'm doing the best I can paying the $50 a month. This would make the payments go up to $100, because both payments would be 50 and 50. So I'll be paying $100 a month, and that's the best I can do. I'm paying all my bills by myself. I'm doing everything by myself.
Mr. Allen, you understand that you paying $50 a month won't be cutting into the actual principal of the debt. You'll just be looking at paying interest on it.
I mean, until my situation changed, that's the best I can do right now, because the $100 a month is just actually making me suffer right now paying the other $50. My job is cutting back on our hours right now, and as we speak, as the first of the year, they're going to be cutting back some more. So I'm serious. I'm struggling.
Mr. Pop-Up, the only thing I can do now, the only thing that I think is, and that's why I'm asking if you want to meet with Mr. Allen, I can place a time frame on this so that we could do it for 3 months and then see what Mr. Allen. But I'd like you to be involved in any of those negotiations. Did you want to talk to Mr. Allen about any of this? Because I don't see an easy way out for Mr. Allen, because all of this is just going to the interest amount. So the principal is not changing in any way. I think the principal is probably growing in this.
Yeah, Judge, I wouldn't be opposed to doing like a 3 or 4 month review. I'm doing like 50 a month until that point, and then hopefully in 4 months or so we can bump that up to at least cover. So I want to say it's around like 150, 160 the interest rate. So closer, I think, to 200 a month would be a start.
Right.
but we can
So-
do a few months just to kind of give them a head start.
All right. All right, so Mr. Allen, that's going to be the ruling of the court. I'm going to grant your motion to pay $50 a month, but we're only going to do it for 4 months. All right.
Okay.
So you pay $50 a month for 4 months, starting February 1st. That'll start February, March, April, and May, and then you're back on your regular installment payments. So hopefully you can get back on your financial feet and pay some of this. But that would be, so it's the ruling of the court to pay $50. I will grant the motion to order installment payments for $50 a month, but only for 4 months.
Okay, and then what do we do after that?
Well, after that's going to be reassessed between yourself and the Credit Acceptance Corporation, because we want you to be making effective payments towards the debt, to the nature of this debt at that time, and that's probably going to raise up. But that may come in front of me, but I'm only going to okay this for 4 months.
Okay, can I ask a question, Your Honor?
Sure.
How is this debt still drawing interest and my other debt from the same company is not drawing interest?
Well, you've signed you have 2 different debts.
I understand that, but on this debt, I was a co-signer.
It doesn't merge. The interest doesn't merge altogether. You owe an interest per each debt. I'm assuming that's correct, Mr. Popov.
Yeah, I don't know. It could be another law firm that represents Credit Acceptance in the other matter. So I can't say with complete certainty that they did or didn't take off the interest. But I know from experience, if it's an older debt, sometimes they do drop the interest.
Right.
So it might have been.
Mr.
Sorry, Judge.
Okay, so can I ask you another question? Okay, so this debt is initially not mine. I was a co-signer. So can we
And
Mr.
Allen, I'm not gonna relitigate the debt.
Okay, well, I'm just saying,
Yeah,
I'm trying to make a deal, but if you want more money,
Right.
I'm trying to say maybe we could go after the person who initially did this and then I help them or something
Well, as
like
a
that.
co-signer, you're on the security for the same amount. I'm gonna place this for 4 months. So this is set for February.
I understand that, but the
February,
person who
March.
did it is working and I'm barely working.
April and May at $50 a month. And then it'll go back to the initial amount that I'm assuming this was this being garnished at that time?
Yeah,
Mr.
so
Popov?
Judge, it looks like it was. We did recently get a garnishment, and that's why he filed the installment payment. So I would, if we can, Judge, I would request that we do get a hearing in 4-ish months, 5 months.
Yeah. So let's set it, we'll set it for a control date hearing. A control date hearing, and this will be set. So February, March, February to March, March to April, April to May. So let's set it for June 1st or in that vicinity. I don't know what day it'll be, but because it starts in February.
Okay, Your Honor, I got another question.
Let me get this date.
Okay.
June 2nd. This is way out for us. So right now, June 2nd at 8:30 is the anticipated date for the control date to make sure the payments are being made. So I'm gonna accept that the defendant must pay the judgment installments as follow, starting February 1st, the $50 a month. I'll check box 4. The garnish is suspended, but then we'll come back and we'll revisit this to see where we're at on June 1st, because Mr. Allen, you could be back to making those garnish payments in the same matter. Mr.
Well,
Allen, do
let's
you have any
do
questions of
something
me?
to avoid the garnishment. I don't want the garnishment. I can make
Well,
installment payments and maybe I can work out something better by June.
I think you may
but I
have to
think-
do that June 1st, Mr. Allen.
Well, that's what
June
I'm saying.
2nd.
I'm appreciating the court giving me time to get prepared for this, but I don't want the garnishment. Let's just come up with some type of installment payments, but maybe not as much, because the garnishments is actually getting me for a lot. That's what's killing me right now. Got me under eviction at my apartment and everything.
Well, Mr. Allen, you're free to talk to Credit Acceptance Corporation or their attorney concerning this matter anytime before June 2nd. By the time it gets to me June 2nd, we have a whole different deal, all right? Do you understand that, Mr. Allen?
No, sir, I don't.
All right. So you may want to talk to Mr. Popoff or the representative of Credit Acceptance Corporation, but this will go on for 4 months at your request.
Okay, so after the 4 months, we're gonna come back to court.
June 2nd, we're going to revisit this to see what you've come up with, because this is only going to last from February to June. February, March, April, May. Yep.
Okay, I understand that. So
All right.
So you're giving me time to come up with something. That's what you're saying.
Essentially, yes. And it would probably be a good idea, Mr. Allen, to talk to somebody from Credit Acceptance if that garnish waivement. This is 4 months for you to get back on your financial feet, so some time to reassess.
Okay.
All right. Is that a fair statement, Mr. Popoff?
Yeah, I think that's fair, Judge.
All right.
Mr. Allen, the garnishment will be suspended since this is an installment payment order by the court. So you won't have to worry about the garnishment. And then
we've set it for control date on June 2nd.
we do have the review. More, but it would still be an installment payment order. You wouldn't be getting garnished. So
correct.
Okay.
All right. I will see everybody on June 2nd. Mr. Popoff, thank you for your appearance. Mr. Allen, thank you for your appearance.
Thank you,
Okay,
Judge.
thank you,
Real
sir.
quick, Judge, can we have this
Yes.
over Zoom as well? The June 2nd one?
Yes, definitely over Zoom.
Oh.
And the order's already set on so the parties don't have to follow up with an order since I just signed the one that was in the file.
Okay, Your Honor.
Yes.
They have my address wrong. The way I found out about this Zoom thing today, I happened to be calling the court to find out what happened to my case, and they informed me that I was supposed to be in court today. So they have my address on file wrong, incorrect. So I didn't even
We have 1111 Elmwood Road 1023.
Yes, sir, but they sent my notice to my last address. He just told me it was returned Friday. So between there and there, somewhere has my address screwed.
They might have a previous address of 722 West Ionia. Is that your previous address?
Yes, sir. That's where they've been sending stuff.
All right, let me make sure it's updated.
Okay.
So in our computer, it's 1111 Elmwood Road 1023, Lansing, Michigan 48917.
Correct.
All right. We've got that as the updated address.
Okay, thank you, sir.
All right, you're all set, Mr. Allen. Thank you, Mr. Popoff.
Thank you, Judge.
Okay, thank you. Bye.
All right, next we have Velocity Investments. That one I don't have a paper file. Velocity Investments versus Hunter Yang. Will the parties please introduce themselves for the record from Velocity Investments?
Good afternoon, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
All right, and it's Mr. Sean Bodon?
Bodwine.
Bodwine, all right. I do not have a Hunter Yang in the Zoom courtroom or the physical courtroom. Let's call the hallway just in case. I don't have a Hunter. I'll tell you right now, I don't think we have a Hunter Yang for the pretrial motions for the pretrial let me see if we got notice today. So there's no Hunter Yang in the hallway. And he was personally served, Mr. Beaudoin. This was set for 2:30. And it's now 3:16. We do have personal service for the pretrial. Mr. Beaudoin, how did you want to proceed?
Requested default judgment, Your Honor.
Okay. Do you have any terms you want to place on the record?
I can put the dollar amounts if you'd like, but
It's up to you. As long as you followed up with an order for the default for fail to appear today, that you can place the terms. This started out, I mean, I know this was a pretrial discovery suit. So if you want to place any terms on the record concerning what Velocity Investments was suing Mr. Yang for, but Mr. Yang has failed to appear.
I'm good, Your Honor. We'll just send in the.
Okay. All right. So order to follow.
Do you want it under 7-day or just submit it?
Under 7 days, fine, Mr. Woodine.
Thank you, Your Honor.
All right. So I'm going to indicate that the defendant failed to appear as indicated, and order to follow under the 7-day rule.
Thank you, Your Honor.
Anything else for the record in 2405692, Mr. Bodine?
No, Your Honor. We're all set.
You should be all set. Thank you for your appearance today.
Thank you.
All right, give me 1 second to clean up that civil, and then I'll start calling. I've got one civil case left, and then the Eaton County case. All right.
Sorry, I have background noise. Are you trying to queue in Eaton County?
All right. I've got one civil case in front of you. I think the translator's here, but neither of the parties are here. So you are correct, sir, right? You're the translator.
Yes.
All right. I don't see it Ahmed El Hout or Ayana Lem here. But give us 1 second. And let me add this note, and then I don't want to keep the translator here if he's just hanging out. That was scheduled for 3. Let's go ahead and do the criminal case, and then we'll see if anybody shows up from that, because we're only 15 minutes into that. All right. All right, Mr. McHugh, is your client on a tablet from Eaton County?
He could be either on a tablet or via.
All right, I see them. Kind of see them here.
For Bonham.
All right, so for Bonham, you'll have Mr. Bonham on the tablet there.
Yes, Judge.
All right. All right, so we're on the record in docket 24-1091, and I'm the visiting judge on the matter from Eaton County concerning this case. Appearances for the record, Miss Oberleiter.
Good afternoon, Your Honor. Kayla Oberleiter for the people.
Michael
Mr. McHugh.
Michael McHugh from the Eaton County Public Defender's Office on behalf of Jerron Bonham.
All right, and sir, you are, let me get your name correct. You are Jerron Bonham, is that correct?
Yes, Your Honor. Yeah.
And you can hear me, Mr. Bonham?
Yes.
This is the time set for a pretrial in the matter. We previously met and adjourned it to today's date. Ms. Oberleiter, how are we proceeding today?
Thank you, Your Honor. It is my understanding that Mr. Bonham will be pleading no contest today to counts 1 and 3. The people will be dismissing count 2, and that there will be no further agreement as to jail time or probation.
So plead to counts 1 and 3, dismiss count 2. That's a no contest plea. And what is the purpose for the no contest plea, Ms. Oberleiter?
Lack of memory, Your Honor.
Okay. And Mr. McHugh, is that a full statement? It is the defendant's request to plead guilty to counts 1 and 3. Counts 2 are to be dismissed. This is a no contest plea due to lack of memory.
That's correct, Your Honor.
All right. So, Mr. McHugh, may I inquire of your client of his no contest plea, his jury, the rights he's waiving in this misdemeanor plea?
He has been informed of those rights and waives them for the no contest plea.
All right, thank you. Mr. Bonham, you understand that for counts 1 and 3, the ultimate punishment could be 90 days and or $500. Do you understand that, sir?
Yes.
All right. You understand you've waived your trial rights, but I'll just indicate them for the record. You understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Michael McHugh. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Eaton County or people of the state of Michigan. You understand that, sir?
Yes, sir.
I don't know what you just said, sir.
I said yes, sir. Yes, Your Honor.
Okay, thank you.
I was cleaning something up on the floor, so.
All right. You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If you're please accepted, you'll give the claim the plea was a result of any promises other than what's stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial today, you'll be pleading guilty to counts 1 and 3. Is it your intent today to plead guilty to the resisting and obstructing in count 1 and the disorderly intoxication in count 3? And I'd say plea no contest. I should say plea no contest to counts 1 and 3. Is that correct?
Yes.
All right. And I'm in possession of the incident, Eaton County Sheriff's Department, case number 2024-0004930. And Mr. McHugh, this will be used as the factual basis for counts 1 and 3. Is that correct?
That's correct, Your Honor.
All right, Ms. Oberleiter, that I'm using the correct police report in that case number for the factual basis. Is that correct, ma'am?
It is correct, Your Honor.
All right. So let me take a look at this. And in relation to count 1 for activity that occurred on September 30th, on or about September 30th, 2024, it appears that this was on or about that September 29th, 2024 to September 30th, 2024, that it appears that the Delta Patrol units were dispatched to 304 Theo Avenue in Delta Township.
Yes.
Right. And here's a Mr. Bonham was passed out, lying on his back. There was an odor of intoxicants. Here that Mr. Bonham refused several orders from Deputy Ritter in regards to touching him. Took a swing at Deputy Ritter, hitting Deputy Ritter. Continued to use vulgar language towards the deputies. And then fought with the deputies in regards to attempting to pull away, turning them around. Some of this was caught on body cam. So as to count one, for the Delta Township ordinance of knowingly or willfully resisting, obstructing, interfering with, or opposing by physical or non-physical means any law enforcement officer or other duly authorized person, while said officer or person was engaged in lawful acts, attempts, and conduct in the enforcement or execution of any law enforcement ordinance, order, resolution. It would find that the factual basis for the no contest plea has been met by the Sheriff's Department, case number 2024-004930, in that Mr. Bonham seemed to strike and or resist Deputy Ritter after being found passed out lying on his back. In count 3, which is the misdemeanor for was intoxicated in a public place while endangering directly the safety of another person or property, or is acting in a manner that causes a public disturbance, it would appear that the factual basis, the no contest factual basis pursuant to case 2024-0004-930 has been met in that Mr. Bonham was found intoxicated and was a threat to himself or others at the time he was found, contrary to Delta Township Ordinance 28-85. So I find counts 1 and 3 to be factually met pursuant to the Eaton County Sheriff's Department police report. Anything towards the factual basis or the no contest plea, Mr. McHugh?
Nothing, Your Honor. Court has complied.
All right, Ms. Oberleiter.
Nothing, Your Honor. The court has complied with the court rule.
Okay, I find the facts of counts 1 and 3 are met through the no contest plea. I'll dismiss count 2 as part of the negotiations. And that will be dismissed pursuant to successful plea and sentence. So, Ms. Oberleiter, I would think that we'd refer to probation. Would that be Eaton County probation, unless you see things differently?
Yes, Your Honor, in this case, and I do believe Attorney McKee would agree with me that this matter be referred to probation for a PSI to be generated.
All right.
I concur with Ms. Oberleiter.
All right.
I'm sorry,
so,
Your Honor.
Mr. McHugh, you would concur with that?
I do, Your Honor.
Okay. We'll refer to probation, and we have a sentencing date of
February 11th at 3.
So we'll set it for February 11th at 3 o'clock. By that time, I'll have a pre-sentence investigation report done. And then Mr. McHugh and Ms. Oberleiter, you'll have the opportunity to see anything from the probation department in relation to sentencing. So we've set the sentencing date for February 11th at 3 o'clock. Probation will be out to see you, Mr. Bonham, from the Eaton County Probation Department in order to set up to see what options are available to us at sentencing on February 11th at 3 o'clock. Anything else towards 24-1091, Mr. McHugh?
Nothing, Your Honor.
Ms. Oberleiter, do you have any questions of me or any comment on the case?
Your Honor.
All right, Mr. Bonham, I'll see you on February 11th at 3 o'clock. Thank you for your appearance, everybody. You're all set.
Thank you, Your Honor.
Thank you, Your Honor.
Sir, you can come up here. I don't think we have anybody else here.
Unless you have them in your packet.
Not unless I don't. All right, so we are on the record in docket 23-01644. And that is Ahmed El Hout versus Ariana Lem. This is the time set for a discovery proceeding in which we did order a translator for this for this discovery proceeding. And please state your name and spell your first name and last name for the record, sir.
Edward, Edward, last name Eid.
All right, thank you. It appears that this was set for 3 o'clock. It is now 3:31. I do not see either party, Mr. Ahmed Al-Hout or Ariana Lem, here. We've got nothing in writing from this civil department that they're running late. I do not see them in the Zoom courtroom or physical courtroom. It would appear that the plaintiff and the defendant have failed to appear for the discovery pretrial. As indicated, this appeared to be started with a subpoena for copies and subpoena for records that was initially sent by Mr. Al-Hout to Ms. Lem for today's date at 3 o'clock. And neither party has appeared. Ms. Lem may or may not have gotten notice, although I have notice in the file. Mr. Al-Hout definitely would have had notice because it's his motion. So, so at this time, I'm going to dismiss this case for both parties failed to appear. And that's all for the record in 23-01644 GC. The case is dismissed for failure to appear both parties about a half an hour late. So you should be all set, sir.
Thank you.
Thank you.
This is already disclosed. There's no need to do an order because it's just the discovery. It's already been a judgment.
All right, I'm gonna write all this.
Yeah.
So, well, I might leave it to you to.
There's nothing for me to do. In this particular situation.
All right.
That I'm aware of.
I'm not aware of.
I just put neither party appeared, interpreter was present.
But, and so let's see, but, so velocity, I had a file on, Al-Hout, I had a file on. I just want to make sure, so you can get rid of those.
Getting rid of. Wait, velocity investments be Yang?
Be Yang.
You had a file on?
No, that's one, let's see.
That
One of these I didn't have a file
That
on.
should have been the one that you did not have a file on.
Pretrial default judgment order to follow. Okay, so I can get rid of that one.
Okay, you can close that out.
All
All right, there we go. I was like, wait a second, I could have swore we called that.
We did, not very long, and then you got rid of the other one.
Yes, okay.
All right.
I was like, huh? Well,
It's kind of a broken up day.